A summary of everything that is stated in this video may be found on the CoinMarketCap website. I would also like to remind you to give my channel a like and subscribe to it so that you can stay up to date on future XRP news, as well as other cryptocurrency news in general. Take a look at this now, shall we? A judgment on Ripple XRP programmatic sales will be appealed by USAC through the year 2023. Before we move on, at this very moment there is a brand new cryptocurrency airdrop that is currently taking place and is set to activate at any moment. If you would like to participate in this airdrop on Telegram, please take your time and click the link that is provided in the description of the video. Please do not miss out on this opportunity if you were unable to participate in the Dogs and Hamster Combat airdrop. Now, let's go with our video. Let's continue with our video. In the appeal that was submitted by the Securities and Exchange Commission, you will revolve around a disputed court order that was issued in July of 2023 and recognized secondary XRP sales as non-security transactions. According to the attorney that Turret cites, every single person working at the agency is certain that the controversial decision that Elisa Torres and the United States District Judge came to was completely incorrect. There was a substantial amount of criticism that was directed toward the verdict. Considering that United States District Judge Jed Rakoff has voiced his concern with the idea of drawing the distinction based on the manner in which tokens were brought to market. The next step that the Securities and Exchange Commission will do has been the subject of a great deal of speculation ever since the judicial ruling in the Ripple case was handed down. In addition, it is essential to take note that the organization is obligated to submit an appeal by the 7th of October before the deadline. Stuart Alderode, the chief counsel for Ripple, mentioned in a statement that he would not be surprised if the Securities and Exchange Commission's SE filed an appeal. On the other hand, he is very certain that the legal status of XRP will not be affected in any way, as this is the law of the land. He is certain of this. You Today claimed that Gary Gensler, the head of the Securities and Exchange Commission, has repeated his conviction that Bitcoin is a commodity. Gensler's statement was confirmed by You Today. The legal position of the vast majority of other tokens, on the other hand, is still unknown at this time. At the beginning of this month, attorney Fred Rispoli made the suggestion that the XRP community does not have any need to be concerned about the prospect of an appeal from the SEC. This is due to the fact that the ruling that is presently in effect is not expected to be amended until at least 2026. As they continue their aggressive legal battle against one another, Ripple and the Securities and Exchange Commission (SEC) are continuing their intense legal battle. It was determined by Judge Torres in August that the process of selling XRP on secondary markets to regular investors did not constitute a transaction involving securities. This conclusion was reached in accordance with the ruling that was made. Ripple, on the other hand, was ordered to pay a fine of $125 million because it violated multiple regulations that govern the regulation of securities. On the other hand, despite the fact that the amount would appear to be substantial, it represents a startling reduction of 94 in contrast to the initial request that was made by the SEC. In light of this, a sizable number of industry participants referred to the development as a huge success for Ripple, which gave the impression that the company would be liable for paying the penalty. On the other side, there are many who believe that the organization is more prone to experience difficulties. When it comes to transfers of this kind, the deadline is the 7th of October. Eleanor Tourette, a journalist who works for Fox Business, stated that a former SEC lawyer advised her that the agency will most likely oppose Judge Torsi's 2023 regarding the XRP programmatic sales in the Ripple. This is the most recent instance of this happening. The attorney is claimed to have stated that everyone working at the Securities and Exchange Commission is of the firm belief that the decision is incorrect, that it does not adhere to the principles of good law, and that it should be challenged. The speculations of such a perspective being moved by the watchdog sparked a series of furious conversations on X, which were initiated by the speculations. In response to the situation that was being discussed, a number of users expressed their vehement disagreement. An attorney by the name of Jeremy Hogan, who is well known in the legal community, stated that the Securities and Exchange Commission needs to give careful thought to the question of whether or not an appeal contributes to the fulfillment of its purpose of protecting investors and forming capital. Eduardo Farina, the chief executive officer of Alpha Lions Academy, recently issued a statement in which his statement was made within the context of the ongoing legal dispute between Ripple and the SEC. In a statement that was made by Eduardo Farina, the sexy lawsuit made an effort to aid institutional investors by lowering the price of XRP. This comment is symptomatic of a broader, widespread concern that exists among the cryptocurrency world. The idea that this legal action created a lucrative opportunity for significant corporations to purchase enormous quantities of XRP at lower costs was voiced by a number of members of the community. This legal action, in his opinion, made it possible for such an occasion to arise. A discussion is taking on within the XRP army regarding the basis for the lawsuit. When challenged about the practicability of such a method, one user expressed their concern by using the following statement: with only $55 billion in circulation at $59, that's approximately $31 billion to buy the entire supply. A small number of whales are capable of accomplishing the task with considerable ease. When it comes to purchasing stuff, I don't see why wealthy people wouldn't use their own money. Taking into consideration his speculation, if the elites were interested in purchasing XRP, it would not be hard for them to acquire the whole supply of the cryptocurrency, because it would not be very expensive for them to do so. Rather than resorting to such deceitful techniques, it is possible that a small number of XRP whales may purchase all of the tokens, so completely overwhelming average investors. In the second response, an alternative viewpoint was offered which claimed that the lawsuit is a plan to delay a more significant financial transition. This alternative viewpoint was presented in the second answer. This is an assertion that was made by a certain person. The lawsuit filed by SIC was nothing more than a delay in the implementation of the gold-backed currency system that the QF was planning to implement. This system was made possible by XRP and XLM tokens in addition to ISO tokens. This interpretation is in line with a larger general conspiracy theory that is prevalent within the community of cryptocurrency users. The purpose of this hypothesis is to claim that regulatory measures are a component of a plan that is more closely coordinated in order to unveil new financial systems. Another user came out to appreciate the challenges that Ripple faced during its fight with the Securities and Exchange Commission. His user made the observation that Garlinghouse and Ripple should be held accountable for the consequences of their attempts to innovate and develop a new system that would be of more benefit to the general public than it would be to the elite. In spite of the fact that Farina believes that the litigation was designed to be advantageous to institutional investors, there are users who are doubtful of this position. One user provided the following argument: if that were the case, the price would already be higher. This user was making the implication that the market value of the cryptocurrency would reflect the activity of institutions that were amassing vast sums of XRP. The allegation was made by a different user, and I believe that Gary Gensler in particular is just genuinely that power-hungry and assumed that he would never be checked. It was argued by this user that the lawsuit was motivated more by personal goals about the Securities and Exchange Commission. Gensler is currently being investigated for politically influenced employment practices, and he is receiving criticism for his efforts that are anti-cryptocurrency. Even if it is possible that the SEC's reasons for initiating the action will never be disclosed, regardless of whether or not they are malevolent, the criticism is directed at Gensler. Eleanor Tourette, a journalist at Fox Business, has revealed that a former attorney who worked for the United States Securities and Exchange Commission believes that the SEC would most likely contest the judgment that Judge Analyst Satora has made in the Ripple vote. This information was obtained from the former attorney. This case was filed by the SEC and handed down in July of 2023. A number of persons who are employed by the Securities and Exchange Commission (SEC) are of the opinion that the outcome of Ripple's programmatic XRP sales is inappropriate and ought to be appealed from the current position. Considering that the Securities and Exchange Commission (SEC) has until October 7th to file an appeal, it is essential to continue to keep a close eye on this particular component of the case as it progresses forward. It should be noted that the material that has been supplied is not intended to serve as business advice. In the event that any investments are made on the basis of the information that is provided on this page, there is no responsibility for those investments. Prior to making any choice on investments, we strongly recommend performing independent research and talking with a professional who is educated in the field.